One. Well, hello everyone, and welcome to another episode of the TCLF One-on-One Series. Through the One-on-One Series, we aim to interact with the best legal professionals from India and around the world. Today, we'll be talking about the practice of white-collar crimes in India and ensuring corporate compliance with government regulations. What are the internal investigations that companies do to prevent such kind of incidents, and etc. And we are honored to have Ms. Tanya Ganguli with us today. Ma'am is currently a senior associate at the law offices of Panag and Babu, which is a fantastic and very highly ranked firm in the domain of white collar crimes and corporate internal investigations in India. Ma'am has extensive experience in such fields, and ma'am, it's an honor to have you here with us today. Thank you so much.
Thank you, Shashwat. It's indeed a pleasure to be invited here and speaking to you today. I'm really looking forward to it.
Absolutely, So let's just start by talking about your journey as a lawyer. What inspired you to become a lawyer in the first place?
So it's quite an interesting story. I was in ninth grade in school, and my dad was pursuing law. So he used to get all these commentaries, Bear Acts, etc. home, and I was always interested in knowing, okay, what is this? And criminal law at that time really intrigued me. I used to read his commentaries. I used to make sure that I go through all the Bear Acts, try to understand the basic nuances. Of course, I did not understand much, but whatever little I could, it really piqued my interest in the profession. Thereafter, I had a bad experience with law enforcement because of a cyber stalking incident, because of which it further got me thinking about the system and probably making a change within the system. So law was an obvious choice. And right after school got over, I enrolled myself in a law school. And that's how it started.
That's a very interesting and brave story to hear, ma'am. Like personal experiences shape up our career options quite a lot, and it's fantastic to hear that they played a part in you becoming stronger and stronger as a professional in terms of a lawyer. So that's fantastic to hear. Now, you mentioned that you developed an interest in criminal law. So how did you come about in the area and in the practice of white collar crimes, which is a very fascinating and interesting field in itself? Like, what was your first encounter with this subject, and what attracted you about it?
So that's a very good question. Actually, white collar crimes generally is not a subject which is widely taught in law schools, and it is not something which is which is greatly discussed probably in a lot of law schools in India. I was lucky enough to have found this law firm in my final year of law school. Panag, who's the founding partner, is also from my college. So I reached out to him. I reached out for an internship. And it was just love at first sight with the work. I mean, I saw the work. I saw the kind of, the cases that were being handled, the kind of laws that were being looked at. And it was just something which I had never read before, which I had never worked on before. And it really piqued my interest. And, I'm sure you would know that we're dealing with the FCPA, the UK Bribery Act, the Prevention of Corruption Act. We have, we look at the CARO 2020, the Foreign Contribution Regulation Act. And these are all laws that, really got me interested within, and looking into the cases that were going on. So, it was just the first internship I did in this firm. And I just loved the work that was that they were doing, and since my final year of law school, I've been working with them, and it's just gotten better over the years.
Fantastic to hear that, ma'am. And what's something really interesting about white collar crimes and the practice dealing with such crimes is that the kind of impact that these crimes have on the overall economic structure of the country, and the kind of impact that these crimes have on the system itself. People often ignore this area, or are not very much interested in this area, but the kind of impact it has, I think we need more lawyers to specialize in this area, so that they can advise these corporations and companies better. Now, just to get into the specifics, not very much, but a bit, of course. what are the different legislations, that in India specifically that deal with white collar crimes and which deal with the prevention of such crimes, basically?
Mhm. So I'll start with the basics. Of course, there's the Prevention of Corruption Act, which forms the
Right,
bedrock of almost all the cases that we do. We
right,
have the Foreign Contribution Regulation Act. We have the Prevention of Money Laundering Act. Then there's the Fugitive Economic Offenders Act 2018, which I mean was widely spoken about in the past couple of years. Then
right,
we have the Black Money Act. Of course, then we have the IPC CRPC Companies Act, which predominantly are looked into and in every case that you're dealing in white collar investigations. So that is there. Of course, there's also civil services conduct rules and similar rules and
right.
regulations that are also ancillary to all of these.
Absolutely. Like, and just to follow up to these questions, do you think that the structure, that the framework that is present in India right now, is it adequate, or like are these acts or legislations regularly updated to deal with the contemporary, economic and other business developments that take place?
That's an interesting question. Actually, I'll give you my personal take on this. I think
Yeah,
law in itself is something that needs to be constantly updated, and it needs to be robust enough to look into and to deal with the everyday issues that are cropping up within the society, right? Like, so the law
right,
must be
absolutely.
robust enough to be able to encompass within itself the kind of crimes that are being committed. So any law, it's not specific to white collar investigations or public procurement or something of that sort, but it's just any law
Right,
which needs to be robust enough to be updated at a regular basis, to take into consideration all the lawbreakers and what they are doing in the society to
right,
basically encompass that. I think the Prevention of Corruption Act recently had an amendment in 2018, and
right,
I think there is the economy is or the governments are making an effort to make sure that the laws and the regulations, and of course the courts as well, are trying to make sure that the laws are in at pace with what's happening within the society. So yes, I'd say that these are getting updated. Of course, we had the Caro 2020, which came up, which further
oh yeah,
was a step ahead in ensuring adequate disclosures, making sure that the auditors are disclosing all the relevant
right,
information, so on and so forth. Because of all the crimes that all the cases that we are seeing, we had a Wirecard, we had a Satyam, we had an Enron. So it's very
right.
important that the laws are constantly updated and they are kept in line with what is happening in the society. Yeah.
Absolutely. That's a fantastic take, ma'am. Like, I do not have much knowledge about the way these laws functions. I've never, even in my internships, worked on this subject. But I've read a few news reports and a few reviews, a few articles, wherein they talk about the revealment of such crimes or how these crimes actually come into the spotlight. And one very interesting thing that I noticed was the role of whistleblowers. I read that sometimes whistleblowers from the companies themselves reveal these crimes to the regulators. So, what is the framework regarding these whistleblowers, and what sort of protection under the Indian law these whistleblowers are granted?
Right. So, whistleblower protection is something which is embedded or inherent in within the Indian legal system as well. I'll
Right,
start with the basics. It's the Companies Act which you first look into, and the rules which are made thereunder. There is Section 177, which deals with the vigil mechanism and how a vigil mechanism must be established for directors and employees to report genuine concerns and the grievances in a manner which has been prescribed under the relevant rules thereunder. So that's
right,
one of the basic legislations that you go back to in terms of whistleblowers and whistleblower protection and how it should be looked into.
right,
Thereafter, we had the SEBI LODR regulations, which were in 2015, again furthering on the entire vigil mechanism concept and talking about a reward mechanism for incentivizing informants to report the violation of insider trading laws to SEBI. SEBI had also recently come up with other rules and regulations which deal with further protecting whistleblowers because of the sensitive nature of this entire disclosure that whistleblowers get into. Like they're providing sensitive information, and it's extremely critical to ensure that uh, they are protected from any sort of any sort of backlash from the company or from anyone else, third parties, etc. So it's supremely critical to make sure that the protection is given at due credit and due importance. So thereafter, we have the SEBI prohibition of insider trading regulations, again, which talks about, as I said, the reward mechanism for incentivizing informants.
Right.
These three are some of the more widely spoken about provisions. There's, of course, also the CARO 2020, which brought with itself the disclosure of whistleblower complaints received during a financial year, further talking about this entire concept and how whistleblower protection is one of the most critical aspects being looked at by regulators.
And ma'am, before coming into this formalized structure of investigations wherein the enforcement agencies carry out these investigations and, procure the records of such companies and try and analyze them, what are some internal mechanisms? I'm sure that these companies must have some internal mechanisms or internal investigations in place to keep a check on the activities of the companies, make sure that such kind of instances do not take place. So what is the effect of such investigations that take place? Are these effective?
Yes, of course they are. So most of the companies today have their own set of code of conduct. They have their own set of rules and regulations which mandate them to have a robust whistleblower culture, wherein if there's any whistleblower who wants to disclose some information, there is an entire system which is prepared so that they can put forth their grievances, their complaints,
Right.
in a manner which is confidential and is also looked into. A lot of these are handled by the compliance officers of the companies because because they are the ones who look into all these complaints, and then it can either be, so investigations can also be of different types. It board mandated investigation, it can be an audit committee mandated investigation, it could also be a legal department mandated information, depending on the nature of what the investigation is. But in most cases, yes, there is a speak up culture or a system in place to look into these whistleblower complaints. Now, these are very important for a company, both from a curative as well as from a defense standpoint. From a preventive as well as defense, I'd say. Firstly, you would want to ensure that if there is a whistleblower complaint, you'd want to ensure that it's plausible. It is something which is, this could have happened, and you conduct this investigation to see whether or not there are any loopholes within the system, whether or not the internal controls of the company are robust enough to take care of such kind of issues within the system. Now, first is this: if there are any issues that are noted, you would obviously want to improve your compliance compliance policies within the system. You'd want to improve your code of conduct and other ways in which employees are dealing with situations in a better manner. You'd also want to ensure that the internal controls are strong enough that these instances do not happen in future, because uh, it will obviously have a detrimental impact on the overall company per se. Next, it also has a defense purpose. I mean, a purpose from the defense standpoint as well, because if, let's say, for instance, there's an FCPA investigation, the law enforcement provides cooperation credit in case the company is willing to cooperate with the enforcement agencies, and if they are willing to provide information and help the enforcement agency in looking into the misconduct and taking corrective steps thereunder. So this is one of the ways in which the company tries to prove that they were not at the wrong. This conduct was not a tone at the top, and it was rather action or misconduct by some rogue employees within the system, and they are trying to also look at what went wrong, and basically they are also the victim to this entire misconduct that took place. So it has multiple benefits. Of course, you also want to ensure that the internal controls are strong enough, because if it's not, and if there are multiple instances like these which keep happening, it'll have a bad reputational damage to your company as well. So it has multiple benefits. And of course, one last benefit, of course there are a lot, but one last benefit that I'd like to bring up is, once you have an internal investigation, and if you decide to go into litigation, or eventually all the findings from your internal investigation eventually some way or the other are helpful to you in your defense preparation and defense strategy as well. So these are some of the few benefits
so
of
from
doing
a very
it.
simple viewpoint, from a defense perspective, it acts as a mitigating factor, that we were making sure that we have conducted regular investigations, and we were making sure that such things do not happen. Nevertheless, they have occurred, and these are our findings, and we want to cooperate in the process. So that just acts as a mitigating factor, and factually as well.
So absolutely, a mitigating factor, as well as something that which will help you in your defense further, because you'd say that, okay, we have, even if there was this issue, we have taken adequate remediation measures to make sure that this kind of conduct is not repeated in future. So all these small things also add to this.
Just out of curiosity again, ma'am, do all companies have these internal investigations process, or only is there some threshold that you must have reached a particular annual turnover, for example, to have, or something like that, or even the smaller companies have these kind of investigations?
So if you see the Companies Act, if you see the LODR, there are certain thresholds that are maintained, but I'll tell you how mostly an internal investigation comes into play. There would be the companies in the US, Germany, Spain, other jurisdictions, and they would have their subsidiaries or their operations in India as well. Now, let's say, for instance, the FCPA, and the FCPA law has an extra jurisdictional or an extra territorial jurisdiction. What that means is that if the company's subsidiary, or if they are doing business in India, conducts or involves themselves in a particular kind of a bribery or a misconduct, they are also liable under the FCPA. So now what happens is that the US based company would appoint an internal investigator in India, preferably in India, because they would know how the systems work within India, and the local counsel would conduct the investigation on the subsidiary. They would, and these engagements are mostly these can be with the audit committee or the board mandated, and the local counsel, once they conduct the investigation, they would submit a report to the audit committee or the board who has appointed this local counsel. And depending on what the results are, they would either take remediation action, or they would look at employee termination, or whatever steps they would have to take in that regard. So also one more point is that in India, it does not matter if the bribe is for 500 rupees or 50,000 rupees or 5 lakh rupees. So there is no threshold for bribery per se. So it does not matter even if it's a 50 rupee bribe or a 100 rupee bribe. It will essentially be, under the law, be looked at with the same lens as a 50 lakh rupee bribe. So there's no threshold in that sense. So
that's very interesting to hear. That's a really good area to work in. It's very fascinating to hear all this. Now, building on that, we've seen in the recent past, and even not only in the recent past, but if we delve into the history of the Indian markets, 1980s, 1990s, we've heard that most of these crimes, they occur in the banking and the financial sectors. So I just wanted to ask, why is it so that these sectors are more susceptible to these briberies and white collar crimes? And what are some preventive measures that the sector can in itself take to prevent such kind of instances?
So I think most of these white collar crimes, which are much talked about, are
Right.
from the financial sector, the banking sector. But I would disagree that these are only the areas or sectors wherein
Right.
these instances happen. It can happen. It has happened in the tech sector, the pharmaceutical sector, the healthcare industry. It has also occurred in renewable energy sector. So it's pan sectors, like it has
Right.
occurred in almost all the sectors that you can think of. Some of the recent ones that you can talk about is um, in the Cognizant case that happened, or the Uber
Right.
investigation that was going on. Um, and it's honestly not a sector specific issue per se, but yes, the
Right.
ones which are talked about are mostly, the bribery, sorry, the financial sector ones. You talk about those those
Yeah.
are more widely discussed as compared to these ones. So yeah.
I think this is because of the public impact that these sectors have. I think people are more directly connected to such sectors and they experience it every day. So these
Hmm.
come into the picture or into the light even more. I think
Absolutely.
that's one of the reasons. And like just
Absolutely.
to build on that, why is it like multiple times what happens is that these activities or instances are revealed at a much delayed stage. So what all factors contribute in such investigations? Why is it so?
Because the internal investigation by its very construct is supposed to be a confidential exercise that is conducted between, the entity, or the entity which
Right.
is engaging the legal counsel and the legal counsel. So it's more of it's more of a confidential exercise that is conducted, and only at the time of
Right.
disclosures, when the disclosures have to be made, is when people actually get to know about it. The shareholders would get to know about it, third parties would get to know about it, the market in general would get to know about it. So
Right.
which is why I think these come into light a lot later than when it actually happens. So yeah,
Right.
I think that's one of the reasons why this is the delay that happens now.
Yeah.
Even if you see
That
the
was
Even if you see the
right.
Mondelez case, which happened like long back, the Mondelez case in India. Now, the litigation and the relevant law enforcement actions are happening now. So now
Right.
people have started talking about it, but Mondelez happened like long back, and the
Right.
investigation happened long back. So I think it's about the disclosures, and when it starts coming to public light, of course, when the courts start taking cognizance of it, when the charge sheet is filed.
Right.
So that's when I think it gets a lot of media attention as well, which is how people get to
Yeah.
know about it.
So in a way, these come into the public light or into the light of the media much later, but the investigations and the enforcement starts taking place very early into the
Much
process.
earlier. Yes, yes.
Yeah.
So the investigation would start essentially after let's say the company receives the whistleblower complaint. They would receive the
Right.
whistleblower complaint. They would probably do a plausibility, an overview plausibility assessment to see whether it's plausible or not, and then they would hand it over to a legal counsel to conduct the internal investigation. So that happens at a
Right.
prior stage, and then after, much later, is when the public at large comes to know about it.
Right. That was really insightful, ma'am. And like moving on to the last part or the last question of this conversation. Now, this is something I ask candidly because it is best when answered candidly. So,
Okay.
what are some challenges you have faced, or what are the skills that you have built across these years as a white collar crime practitioner, and what is your advice to some people or the practitioners or the students who have an interest in this area?
I think one of the biggest challenges that I had was that I had never read about these laws earlier in law school. So when I entered this profession, it was all first-hand knowledge. I had spent the first 2 months of my career just reading
Right.
through documents, just reading through the law, understanding the FCPA. And FCPA it's a very, very lengthy law. So reading
Right.
through it, reading through the enforcement actions, reading through what the DOJ says, what the SEC says, what the Indian courts have said about bribery, corruption, fraud, and looking at
Right.
all the the laws and the cases, and just like assessing them was what was, I think, the most challenging. But it was also very, very interesting. Otherwise, it's personally for me, it's not very easy to do
Right.
so much of reading into something completely new. But because it was such an interesting topic, and the fact that the jurisprudence is still so nuanced and it's still developing, you feel that you're
Yeah.
part of the of this entire
Right.
jurisprudence that's being created. And that's what keeps
Absolutely.
your interest alive in it. I think what I've learned through it is, of course, that as I mentioned, that it's a new field, it's an exciting field. One problem that I always face is that, and I'll say this very candidly, it's on a
Right.
lighter note, is that when I say that I deal in white collar investigations, defense, or compliance, the first question that people ask, so are you really a lawyer? I mean, because people haven't
Right.
heard of white collar crimes that much, and they're just like, they have these puzzled looks that, okay, what is that? Oh, do you go to court? Oh, acha, this is
Right.
not what we have heard about. And it's just
Right.
usually met with a lot of puzzled looks from people. So I think that's something which will change in the coming years. And
Right.
yeah, that's one of the challenges, I guess.
So, what is a good place to start? Like, go up and read about these bare acts and these laws. That's a good place to start, or
I think a good place to start would be, yes, of course, go online, and there's a lot of reading material available on these areas. And of course, start
right?
interning at, like, law firms which deal in
Yeah.
these areas. Of course, you can also look at interning with the SFIO or this, all the
Right.
other government agencies, and I think it will just give you a perspective of what is done, how these cases are handled.
Right.
And it's just a great experience. I think, if nothing, you should just intern there to see how different it is from, I think, your other internships.
Thank you so much, ma'am. This was a fantastic conversation, very interesting, and as I mentioned, the field in itself is very fascinating. And to meet a
Right.
practitioner who's so experienced in this field and talk about your everyday experiences, it just makes it even better. So thank you once again, and this was just great.
Thank you, Shasha. Thank you again for having me over. I think this has been a very interesting discussion, and good all great work, and the very best for your future endeavors as well.
Thank you so much.
Thank you.